I'm Atty, Leila, and Lima, here to present the Comprehensive Refugees and Stateless Persons Protection Bill. I would like to apologize ahead of time if my internet connection gets dropped, but I will do my best to. Can you hear me? Can you hear me? Okay. Allow me to start with a brief background on refugee-related legislation and other acts of the Philippine government. Although the Philippines is a party to the 1951 UN Convention relating to the status of refugees, to the 1967 Protocol, and to the 1954 UN Convention relating to the status of stateless persons, presently, the only Philippine legislation that deals with refugees is Section 47B of the Philippine Immigration Act of 1940, which predates these international instruments. Although that provision authorizes the president to admit aliens who are refugees for religious, political, or racial reasons, it nonetheless gives the president an almost absolute discretion in determining the policy on refugees, including there have been two previous notable attempts at further legislation. After World War II, under the term of President Elpidio Quirino, the Philippines admitted refugees from the Chinese Cultural Revolution. But by 1958, there were calls to address the supposed problem of overstaying of refugees. In response, a bill called Refugee Relief Act of 1958 was introduced that would have extended asylum and permanent residency to deserving applicants on humanitarian grounds. Similarly, during the 13th Congress, the late Senator Nene Pimentel filed Senate Bill number 1152 entitled the Vietnamese Refugee Social Integration Act of 2004, which aimed to grant permanent residency status en masse upon due registration with the Bureau of Immigration to Vietnamese refugees who arrived between January 1, 1989 to December 31, 1995, and to their children who were born here thereafter. It further granted the eligibility for citizenship after 5 years from the grant of permanent residency. Unfortunately, neither of these bills passed into law. There are, however, several executive acts that have together embodied the Philippines' long-standing and politically transcendental tradition of extending the humanitarian spirit of giving aid to refugees. In fact, during the height of the Rohingya boat tragedies, then Secretary of Justice Lima had occasion to call attention to the Philippine government's long history of accepting refugees, including but not limited to the Jews escaping Nazi persecution during World War II, refugees escaping the communist takeover of mainland China, and the establishment of refugee centers for Vietnamese boat people in the 1970s. Some of the notable executive acts that embody this long-standing tradition are as follows. Former President Ferdinand E. Marcos issued Letter of Instruction number 270, series of 1975, allowing for a simple administrative procedure in gaining citizenship, leading to, in particular, the mass naturalization of former Chinese refugees who were then dubbed as migrants. 4 years later, he issued Executive Order 554, series of 1979, creating a task force on international refugee assistance and administration, which was primarily mandated to respond to the request of the United Nations High Commission for Refugees. It delineated the initial steps that are to be immediately taken to get the task force operational, including the designation of Tara Island and Ulugan Bay in the province of Palawan as refugee centers and camps, and the giving of instructions to, among others, the flag officer in command of the Philippine Navy to assist the task force in providing for ferry service for materials, men, and equipment needed to construct and operate the refugee camps. These efforts were carried on during the term of President Corazon C. Aquino, who, within 6 months of the 1987 Constitution, issued Executive Order number 304, series of 1987, authorizing the task force and the DFA respectively to issue identity papers, and the travel documents to refugees staying in the Philippines. Under DOJ Circular Number 58 Series of 2012, as then Secretary of the Department of Justice, Senator De Lima set up the Refugees Stateless Persons Protection Unit within the legal staff of the DOJ, making the Philippines the first country in the Asia-Pacific region to establish a procedure to protect both refugees and stateless people. During the height of the boat tragedies, she primarily cited this DOJ circular in opposing the initially reported plans to turn away refugees who cannot present travel documents. She clarified that while the lack of travel documents would normally warrant exclusion proceedings, a process is in place to grant genuine asylum seekers the protection of the Philippine government, noting that asylum seekers cannot always be expected to obtain travel documents, particularly where the agent of persecution is the state. Now, since most of these previous relevant and substantial issuances emanate from the executive branch, they are more susceptible to the differing priorities, views, and even whims of the incumbent. There is, therefore, a need to make matters such as the criteria and definition of refugees, the procedure for availing the protections and for the loss of such status in accordance with due process more permanent through a comprehensive law, so as to make these protections more transparently and legally demandable, accessible, stable, and ultimately more effective. In other words, there is a need to take a rights-based approach to refugee recognition and protection. It shall define both the legally demandable rights of rights holders on the one hand, and the duties and obligations of both the state as the primary duty holder and of those receiving benefits under the law on the other. On July 11, 2019, Senator De Lima filed Senate Bill 379 entitled the Refugees and Stateless Persons Protection Act of 2019 to do just that. The bill has a fourfold objective: to strengthen and promote the rights of refugees and stateless persons, to create the Refugees and Stateless Persons Protection Board, to prescribe a fair and efficient procedure for status determination and eligibility for protection, and to strengthen the government's cooperation and coordination with the UNHCR, the Commission on Human Rights, and other relevant institutions and agencies. The bill also provides for the state's responsibilities vis-a-vis refugees and stateless persons, namely, the state shall not remove or expel a refugee from the Philippines to a country where he or she would be at risk of persecution, save on grounds of national security or public order. And the state shall not impose penalties on refugees who enter the Philippine territory illegally if they come from a territory where their life or freedom was threatened, and provided that they present themselves without unreasonable delay to the authorities and show good cause for their illegal entry or presence. No undue restriction on movement or travel shall be imposed other than those which are necessary, and such restrictions shall only be applied until their status in the country has been regularized or they obtain admission into another country. For that purpose, reasonable time shall be allowed for such refugees to obtain admission into another country if they so decide for such an option. The bill also defines the rights of refugees and stateless persons, which are geared towards allowing them to live a life consistent with the dignity of all persons. Among the 10 specific rights of refugees recognized under Section 6 of the bill are the right not to be returned or non-refoulement to a country where he or she faces serious threats to his or her life or freedom, the right to practice religion and freedom as regards the religious education of their children, the right of recognition as regards their personal status, the right to acquire personal properties, the right of access to legal remedies in courts and quasi-judicial bodies, and the right to adequate standard of living, housing, and medical needs, and be provided with subsistence support not less than what is extended to indigent Filipinos. In addition, refugees have the general right to be treated equally with other non-nationals and in conformance with internationally recognized standards. On the other hand, among the 11 specific rights of stateless persons under Section 7 are the right to be accorded the same treatment given to aliens generally, including with regard to participation in wage-earning employment, and the right to property, including intellectual property rights. The right not to be forcibly removed from Philippine territory. The right to be issued travel and identity documents within the Philippine territory. The right not to be expelled except on grounds of national security or public order. The right of access to legal remedies in courts and quasi-judicial bodies. The right to adequate standard of living, and the right to education and learning for both children and adults. As for institutional frameworks and mechanisms, the bill establishes the Refugee and Stateless Persons Protection Board, an attached agency to the day with its own secretariat as the central authority in matters relating to the determination of the status of these persons and their eligibility for protection. Procedural highlights. An application for recognition as refugee state person, which may be filed either directly with the Protection Bureau or through the Bureau of Immigration at any ports of entry, automatically suspends any deportation proceedings for the applicant. The burden of proving a claim to refugee or stateless person status is a collaborative effort by the applicant and the protection officer assigned to the case. And the applicant has the obligation to provide accurate, full, and credible account or proof in support of his or her claim. The jurisdiction for initiating whether motu proprio or upon verified complaint and deciding the cancellation, revocation, cessation of refugee or stateless person status is with the Protection Board. However, the decisions of the Protection Board are subject to judicial review under Rule 40 of the Rules of Court. Among the substantive highlights, the bill also provides the following substantive safeguards that aim to ensure that the rights are legally demandable and can only be denied or withheld for cause defined under the law and in accordance with due process. First is the provision under the law of the definition of refugees and stateless persons, which minimizes the discretion or arbitrariness of implementers in making such a classification or determination. The rights of an applicant, which includes the rights to the services of a legal counsel and an interpreter, access to the UNHCR, and to assistance for PWD applicants. Provisional measures, which aims to extend protections that are reasonably necessary to protect the personal security, liberty, and other property of the applicant while his or her application is still pending. Grounds for exclusion, which basically disqualifies the same persons who are excluded from the application of the 1951 Refugee Convention and the 1954 UN Convention. Grounds for cancellation of refugee status and for revocation of stateless status are also made very clear. It only aims to correct mistake in the granting of applications of those who made intentional and material misrepresentations or concealments, or where new evidence shows that they ought not to have been recognized as such. The grounds for cessation of refugee status and for cancellation of status or stateless status is when it terminates when the protections accorded to the persons who have acquired or reacquired the protection of another country or obtained or reacquires a nationality, respectively. Grounds for removal from Philippine territory, which are basically on the grounds that the public interest is best served by their removal, although it provides for safeguards, including the due process, such as allowing the person to submit evidence on his or her behalf and to be represented by legal counsel, and allowing the person reasonable time to seek admission into another country. It may be notable to mention that another bill is pending, namely Senate Bill 2233, or the proposed Foundling Recognition and Protection Act, which was principally authored by Senator Lito Lapid, principally sponsored by Senator Rizzo Antiveros, and co-authored and co-sponsored by Senator De Lima. The proposed legislation aims to recognize the status of foundlings as another category of persons of concern in order to, among other things, reduce and prevent statelessness, considering these children's distinct vulnerabilities to neglect, statelessness, and abandonment. As for the status of these legislative measures, SBN 379, the Refugees and Stateless Persons Protection Act, is currently pending in the Committee on Justice and Human Rights since its filing on July 11, 2019. As to the recommendations for the way forward, we hope that we can all work together in asking the Committee on Justice and Human Rights Chairperson, Senator Richard Gordon, to calendar this bill for hearing before Congress next year so that we can have a head start for it when Congress convenes after the elections. Senate Bill 2233 on Founding Recognition and Protection Act has already been sponsored before the plenary, meaning plenary debates on the substantive provisions are ongoing. Our office is working closely with the Office of Senator Risa Ontiveros in having this bill passed as soon as the budget deliberations are finished. With the House of Representatives version already approved, we are optimistic that it can be signed into law under the present administration. The way forward, we urge that the conclusion of plenary debates after the budget, we urge the conclusion of plenary debates after the budget deliberations. As for the 1961 Convention on Reduction of Statelessness, this year, the President has ratified our accession to the 1961 Convention. The matter has already been submitted to the Senate for its concurrence, and it has since been referred to the Committee on Foreign Relations. Our colleagues from the Office of Senator Coco Pimentel, as well as the Committee on Foreign Relations, in which Senator Leila is a member, seek to have it approved, hopefully by January next year. We urge the committee chairperson, Senator Coco Pimentel, to hear the ratification for concurrence. In the meantime, while these legislative measures are pending, Senator Leila expresses her appreciation for your support for this legislation. It may not be as sensational as other legislative endeavors, but other senators, but it nevertheless demands our attention and stands to help our country in dealing with a growing international concern. Thank you very much.